Tonight we're going to talk about the new tenant buyout rules for San Francisco landlords. So Colin, why don't you go ahead and flip the next slide. So as I said, we're McLaughlin Yeh. Let me tell you a little about who we are and what we do. We are a San Francisco-based boutique litigation firm. And what that means is that we do real estate disputes. We don't do the paper transactional side of real estate closings. We represent landlords who need to evict tenants, or in this case, and especially for tonight, we want to buy tenants out, either because the tenant's a problem, or you want to get the unit back for whatever reason, possession, maybe you want to sell the unit, or whatever the case may be, whatever the case is, whatever your incentive is, and we do that. We also represent business owners in business disputes. That's the other half of our practice. So we have a real property practice, and then we have a business litigation side as well. And my partner, Johnny A, does all the business disputes. One thing that sets us apart from other law firms is we meet with clients. Every client that comes into us, we meet with them one-on-one, and we figure out what the client's objective is, and then we set a clear strategy for getting there. We don't just do things and hope it works out. We actually try to figure out where you want to go, and then put a plan in place to get you there. So that's something that really sets us apart. Tonight I want to give you a roadmap of where we're going on this discussion. The first thing I want to do is I want to talk to you about the incentives for tenant buyouts. And then talk to you about what I call the old regime for tenant buyouts. The old regime is the way the rules used to be before March 7th this year. Then I'll talk a little bit about the rationale for the new rules, according to the Board of Supervisors, why they passed this new legislation. Because it's important to understand, why these new rules came down. Then we're going to dig deep into what is required by the new rules, and we'll go over some of the disclosure requirements, and then the new requirements for buyout agreements, what actually has to be in the agreement itself. And then I want to talk specifically about one critical part of these new rules is the tenant's right to rescind the agreement after they enter into it. And then I want to talk about filing and posting requirements. And then we'll talk about some of the new restrictions on condo conversions for people who enter into certain buyout agreements. And then lastly, and everybody's favorite part, is penalties and enforcement. What happens if you break the rules? And as you see as we go along here, these rules are set up almost like a trap. You're going to see that there are pre-negotiation requirements that have to be made before you actually even enter into a buyout agreement. And there are severe penalties that apply and consequences if you break those rules. Okay? So go ahead. Incentives for buyout agreements. So San Francisco has one of the most stringent rent control laws in the entire country. As I'm sure you all know, it limits the amount every year that you can increase the rent. It also has eviction control, so you can only evict a tenant for one of 16 just causes. And given the rental increase limitations, rents quickly become what I call underwater. They become below market relatively quickly. If you can only rent the unit, or increase the rent on a unit rather by 1.5% a year, and rents are increasing at a rate much faster than that, you're going to find a tenant subject to or having the protections of the rent control quickly under market. Okay, and that's one of the big incentives for doing buyout agreements. 5-10 years goes by and the tenant is still in that unit. The landlord has an obvious financial incentive to want to buy the tenant out, get possession, and then re-rent that unit at the prevailing current market rate. Okay. Also, the eviction control statute in San Francisco has created a very acrimonious landlord-tenant environment in San Francisco. And so a lot of landlord clients that I have want to use buyout agreements to get problem tenants out, to get rid of tenants that are a nuisance or are just uncooperative and so forth. And once once you get possession back, you can increase the rent, get problem tenants out, and if you want, and you're wanting to list the property, you can market the property without a tenant being there. It's easier and better to market the property for sale that way. So let's talk about the old rules, what I call the old regime. Buyout agreements, even under the new agreement, under the new rules rather, buyout agreements are contracts. Before March of this year, those buyout agreements were largely unregulated. It was, the landlords and tenants had the ability to freely contract with one another. People would call me and say, is there any requirement on how long I have to give the tenant to move out under a buyout agreement? No, there wasn't. There isn't any minimum time. You can give them 6 months, you can give them a year, they can move out tomorrow. You can structure the deal any way you want. You could also structure the incentive any way you wanted it. Maybe it's $10,000 would get this particular tenant out, maybe $2,000 would get a different tenant out. And there weren't any rules about how much and how long a tenant had. It was largely unrestricted. There is a point here that lawyers that I've worked with in the past have always had. A question that's always come up is, what happens if a tenant breaches the agreement and doesn't move out? And the question is would you have still be able to evict them, or would you have to go and prove just cause? You'd obviously have a claim for damages for any money that you gave them up front, because a lot of buyout agreements are structured. You give them a little bit up front, and then you get the rest of it when you actually get possession back. And I've actually personally never litigated this issue because I've never had a tenant who breached one of these agreements. Once you get a tenant into a situation that they're going to do a buyout, they enter into the agreement, and then they actually move out pursuant to the agreement. So I've actually never litigated the issue, but it is one that is out there. So new rules were passed. They were passed last October. They became effective on March 7th of this year. And if you read the legislation, you'll see that the Board of Supervisors was concerned specifically about the disparity between rent control and market rate rents. So something we just talked about. Landlords who wanted to sell the property unoccupied, and landlords using buyout agreements to circumvent eviction controls. And what the Board of Supervisors identified specifically was, in some no-fault evictions, like owner move-ins and Ellis Act and so forth, you actually have to pay relocation money to the tenants. And they can run, depending on the number of tenants and whether the elderly or disabled, it could run $15,000, $20,000 for, to get possession of the property back. So if you could enter into a buyout agreement where the consideration is, say, only $10,000, you're saving $10,000 there in some cases. And so that was a big concern for the Board of Supervisors in passing the new rules. So one thing I want to talk about is the applicability and the definitions, which are very important here, and they're very broad. The new buyout rules apply to all landlords and tenants who are subject to the rent ordinance. So if you're subject to the rent ordinance and you want to do a buyout of a tenant who has the protection of the rent ordinance, these new rules will apply. If you look at the definition of a buyout agreement is an agreement wherein the landlord pays the tenant money or other consideration to vacate the rental unit. If you have a pending unlawful detainer action and you settle, you're down in the courthouse and you settle an eviction action, these rules don't apply. Okay, so if you actually are in the midst of an eviction, you enter into a settlement agreement, there's money exchanged for possession. To settle that unlawful detainer action, that pending unlawful detainer action, these rules do not apply. But for other negotiated settlements, under the definition of a buyout agreement, they do apply. So for example, I have a case right now where the landlord and the tenant are nearing litigation, and we want to enter into a settlement agreement prior to an eviction action, prior to a lawsuit. And under the definition of buyout agreement, it is an agreement where the landlord is paying the tenant money to vacate the rental unit. So the new rules would trigger the new rules. And buyout negotiations, this is going to be another very, very important definition here. And you're going to see why in a minute, because there are pre-negotiation requirements that landlords and disclosures you have to make, and also rent board filings. So buyout negotiations are any discussions, written or oral, regarding the possibility of entering into a settlement agreement. So let's take a hypothetical on that. If you have a tenant and you say to tenant, would you be interested in a buyout of your tenancy? It's a negotiation. It's any discussion regarding the possibility of entering into a buyout agreement. So what I'm telling clients now is, if you are thinking about buying out your tenant, before you even broach the subject to the tenant, there are pre-negotiation disclosures that have to be made. And if you don't make them, you're in violation of these new rules from the very beginning. Okay? It's pre-negotiation disclosures. So the the new rules require landlords to provide tenants with certain disclosures before starting buyout negotiations. This landlord who violates the new law at the very outset if he fails to give the required disclosures before approaching the tenant about a buyout. The new disclosures are actually provided on a form that is available from the rent board. And if you have a need to do a tenant buyout and you call me up, we'll go through the whole process to make sure that you give the proper notice. I have the rent board form, or you can go to the rent board and get the form that you need to use. It's a rent board form that you have to use it on the rent board form. The law requires it. Okay. So let's run through what some of the requirements are in the required disclosures. And again, since this is a rent board form, you don't have to worry about crafting this yourself and drafting it up. It's going to be on a form already pre-printed in the rent board. Okay, the required disclosures is a statement. The disclosure has to have a statement that the tenant has a right not to enter into the buyout agreement. In other words, buyout agreements are voluntary. Tenants, you have to inform tenants that they're not a mandatory thing. They don't have to agree to it. You have to advise the tenant that they have a right to seek counsel from an attorney. The disclosure has to state that the tenant may rescind the buyout agreement for up to 45 days after signing. So you may enter into a buyout agreement with the tenant, but you have a month and a half cooling off period where the tenant, for no reason at all, can just call you up and say, I'm not interested in this anymore, I'm not leaving. And the deal's off. Okay, and you have to notify them of that before you begin negotiating with them. You actually have to give a statement that the tenant can find copies of other buyout agreements at the rent board. And we'll get into this a little bit later on. You have to file, almost all buyout agreements have to be filed with the rent board. And they're now going to be searchable. So tenants are going to now, what's going to happen is tenants are going to find out what you paid or what's the prevailing rate under these buyout agreements. And you can see the pressure to increase the amount of a buyout. As soon as somebody gets $60,000 for a buyout, then I think $60,000 for the smart, informed tenant will be the floor, right? You're going to say, well, she got it or he got it, I want it. So that's the new, you have to let the tenant know that these buyout agreements in searchable format are available at the rent board.
Michael, can I ask a question on 45 days?
Sure.
Does that mean that the agreement can't be for less than 46 days, or does that mean the tenant can even 30, but they have the option?
They have 45 days, so you would not be able to enter into a buyout agreement that's for less than 45 days, right? Because they have a 45-day period. Right. So
You couldn't say 60 grand for 30 days then now.
Minimum
45
it's
days.
a minimum 45 days, right? Yep. Okay, you have to inform the tenant, give them a statement that they can find copies of other buyout agreements. You have to also give them a list of tenants' rights organizations so that they can go and get free legal help. You have to provide a statement that the tenant may obtain information about his or her rights from the rent board, and that the rent board has an office, a telephone, or they can get information online. Okay? You also have to tell the tenant the have to disclose the names of the persons who will negotiate on behalf of the landlord. I think this requirement here is for larger institutional landlords, where the tenant may not know who has authority to negotiate for the landlord. So the landlord's actually got to identify the person or persons who have authority to negotiate with the landlord. And that's all these disclosures have to be made prior to beginning the negotiations. They're on the rent board form, and that form has to be given prior to broaching the subject with buyer. Then, again, before you begin negotiating with the tenant, you must make certain disclosures to the rent board. And I will say that this disclosure requirement is on another rent board form, and it's under the penalty of perjury. So you actually have to sign it. You have to file this notice with the rent board. And what the notice basically says is all those requirements that you had to give to the tenant, I made those before we started negotiations. Okay, so you got to make the disclosures to the tenant before you start negotiations. Then you have to file the form with the rent board before you start the negotiations. Okay. If you fail to do this, if you fail to make the disclosures to the tenant and fail to file the form with the rent board prior to negotiations, you're already in violation of the statute.
So the renter does not have to sign this notice to the rent board.
No.
So,
Right. You sign it.
and what if there's a dispute? You say, I did all these things. Later on, they say, oh no, you didn't. So.
Well, you probably end up before the rent board, and it's going to be a factual inquiry about who's telling the truth. Yeah, it puts you in a really, it puts you in a delicate situation.
That's a good question. So when you're giving these disclosures, is there a line for the tenant to actually sign?
Yeah, there's a little initial right there. Yeah, you can get the, if you want to follow up with me, I'll give you the form. You can see it. So these are the required rent board disclosures. When you disclose this to the rent board, you have to give your name, business address, business email, business telephone number, the name of each tenant you intend to buy from, the address of the subject rental unit, and then a statement, as I mentioned, under penalty of perjury, that you provided each tenant with the required pre-negotiation disclosures. Okay, so these are the new rules and new requirements for buyout agreements. Under the new rules, every buyout agreement must be in writing. Each buyout agreement has to include a statement in bold, 14-point type, close to the tenant's signature line, informing the tenant that he or she may cancel the agreement up to 45 days. So I have a standard buyout agreement that I've used for years, but I had to go back in and modify that agreement, and now it has in bold, black, 14-point ink, literally a copy and paste job from the statute, and just copied and pasted it. And it's the last paragraph in my buyout agreement now, because not only do I have to provide it in bold 14-point type, it has to be close to the tenant's signature, so I had to put it right at the end, right by the signature block. You also have to include a statement in 14-point type informing the tenant that he or she need not enter into the agreement and to consult a lawyer, and that the information on their rights is available to the rent board. In other words, inside, you have to give the pre-negotiation disclosures, and then inside of your actual contract, inside of your actual negotiation, your buyout agreement, you have to basically give all of the disclosures all over again. And then you have to include the statement in 14-point type informing the tenant that there are certain restrictions on condo conversions after if the premises has been the subject of a buyout agreement. A buyout agreement that does not include these disclosures is not effective and can be rescinded at any time. And so if you're in the practice of drafting your own buyout agreements, you got to make sure that you go in and modify your buyout agreements to include all the required disclosures. Or if you want, you can come see me. I have a standard form that I use. I usually tell clients of mine, come to me with the material terms. And the material terms I tell most of my landlord clients are how much consideration is going to be, how much are we going to pay the tenant for the buyout agreement? how long do they have to leave, and is there a security deposit, and what is the treatment of that? Is it going to be, give it back? Will it be inspections, that kind of stuff? Those are really the big material terms.
Michael?
Yeah.
I'm sorry, but I'm just not real clear. Include a statement informing tenant of restrictions on condo conversion.
Yes. Yes. You have to inform the tenant within your buyout agreement
Yeah.
that if the premises has been the subject of a buyout agreement, and we're going to talk about the condo conversion restrictions later on,
Okay.
you have to disclose that to the tenant within your agreement in 14-point type.
Oh,
So you mean that you're doing this instead of an LSAP so that you can still convert?
It's just a requirement that you put this, you disclose to them that there are certain restrictions on condo conversions for units that have had a buyout agreement.
oh, okay.
So you've got to put that statement within your, buyout agreement. You've got to inform them that, oh, by the way, for certain, under certain circumstances, a unit will not be able to be eligible for condo conversion after someone's had a buyout agreement in that unit. And that in 14-point type has to go into the agreement.
I see.
Yep.
Thank you.
Yep. Okay, tenants' rights to rescission, we've talked about this. It's tenants have 45 days from the date the buyout agreement is signed by all parties to rescind the agreement. A tenant can rescind by sending a statement to the landlord indicating that you're rescinding the agreement. And the tenant may hand deliver, email, or mail the U.S. Postal Service the rescission statement. Okay, filing and posting. We talked a little bit about this as well. Landlords must file a copy of the finalized buyout agreement with the rent board no sooner than 46 days after execution and no later than 59 days after execution. So you have a short window there. I'm terrible at math, but I'm thinking it's 13 days, right? That you have to, after you finalize the buyout agreement, you've got to wait the 45 days, then on the 46th day you can file it, but you can't wait more than 59 days after signature.
Or what?
Well, we're going to get to penalties and enforcement later on. You had to ask, right? Buyout agreements that are not rescinded need not be, buyout agreements that are rescinded need not be filed. So if the tenant calls you on the 31st day and says, yeah, I'm going to change my mind, I'm going to rescind the agreement, you don't have to file that one. The rent board is going to keep a searchable database of all filed buyout agreements. So we talked a little bit about this earlier. Tenants are now going to have access and see basically what the going rate is for a buyout agreement. And the rent board has promised that they'll redact all private information about tenants.
No, I just noticed that. It's not for everybody.
It's not right? Right. Okay, so we brushed up against this a little bit. Let's talk about the new restrictions on condo conversions for units that have been the subject of a buyout agreement. And it's actually pretty straightforward, but anytime you're dealing in the subdivision code or the planning code or some of the other codes, it can get a little dicey. So the new law amends the San Francisco subdivision code to prohibit certain condo conversions following a buyout agreement. Specifically, under the amended subdivision code, a landlord may not convert a unit to condo if a senior, disabled, or catastrophically ill tenant has vacated under a buyout agreement entered into after October 31st of 2014. So, and you can see the little dichotomy here. These new rules didn't go into effect until March 7th, but for condo conversions, if you entered into a buyout agreement under the old regime, as far back as October 31st, 2014, your unit is no longer eligible for condo conversion. And also, if you buy out 2 or more tenants who are not senior, disabled, or catastrophically ill, after October 31st, 2014, and within 10 years prior to condo conversion. So, essentially, going back to October 31st, 2014, if you buy out 2 or more tenants from that unit in a 10-year period, we cannot condo convert. They won't even issue, if you go into the subdivision code, you can read it, the language is quite prohibitive. You're not even allowed to enter into the lottery, and if you somehow get through it, you can't, it's across the board. It's an across the board prohibition.
Define 2 tenants. Is that 2 tenants in 1 unit or 2 units with 1 tenant each, or does it not matter?
It would be, it's just 2 tenants. I mean, the statute literally says just 2 tenants in a 10-year period. The way I read it is that if you did, the way I read it, it's 2 buyout agreements. So if you do one year and one 4 years later. I mean, that's when you read the statute, that's what it says.
2-unit building.
Yeah.
Get everybody out, that's 2.
Yeah, exactly, right.
What if there were 2 tenants in that 1 unit? What if it was
The
a
way-
landlord situation?
The way I read the statute, it's not really clear. The way I read it is that you're doing 2 separate buyout agreements.
So if you had 2 roommates that you're buying out each one of those roommates?
I think that with the way the statute's not really clear on that, but I think the way the statute reads and feels, the way the intent of the statute appears, is that if you do 2 separate buyout agreements, so you have A and B who's under 1 buyout agreement, and then 3 or 4 years later you buy out the subsequent tenants under a separate agreement. That's what they're getting at.
Okay.
Right. So definitional sections in the rent ordinance, they're often all over the maps. The definition of disability under different types and different grounds of eviction can vary. So I put up here, who qualifies as what under these new subdivision code restrictions. Senior, for these purposes, is somebody who's 60 years or older and has been in the unit for 10 years or more at the time of the buyout agreement. Disabled is someone who's disabled under the Americans with Disabilities Act and has been in the unit for 10 years or more at the time of the buyout agreement. And catastrophically ill is someone who is disabled under the ADA and who has a life-threatening illness and has been in the unit for 5 years or more at the time of the buyout agreement. So, and I will say that this definition of disabled is not the same for owner movement evictions. It's not the same. It's just not consistent across the rent ordinance. So you really have to look in and find out whether this disabled tenant you have meets the definition of disabled under the Americans with Disabilities Act and has been for 10 years or more. Penalties. All right, this is everybody's favorite part. This is the part that we always want to jump to. A tenant who vacates a unit on the basis of a buyout agreement may bring a civil action for failure of the landlord to comply with the pre-negotiation disclosures, or if you failed to include the proper disclosures in your actual buyout agreement, your actual contract. Remember, you got, with respect to the tenant, you got pre-negotiation disclosures, and then your final agreement, which you're all going to sign, has to include those 3 different disclosures. So the tenant can sue you if you fail either one of those. The tenant can recover his or her actual damages plus $500 for failure to make the pre-negotiation disclosures, up to 50% of the tenant's actual damages for failure to include the required disclosures in the buyout agreement, and this is always the kicker, and people kind of read through this a lot, where these cases can get really, really expensive is that they provide for attorney's fees and costs. But only for the tenant. If you're the landlord and you prevail in a civil action, you're not entitled to attorney's fees. The statute doesn't provide it for you as the landlord. It's only a weapon for the tenant. Okay, you don't have a shield yourself. So, as I was saying before we got kicked off here, it's a one-way, in many respects. This statute's a one-way street. Okay, and then, so you're not just going to be liable for violations to the tenant, but the city attorney and certain tenants groups will also have causes of action. Let's go through those. The city attorney and certain tenants' rights groups may sue landlords for failure to file buyout agreements with the rent board. Remember, 46 to 59 days, you have to file that buyout agreement with the rent board. If you fail to do so, you are opening yourself up to a civil action where you're subject to a $100 per day penalty for each document not filed, up to $20,000 in a single action. And if the city attorney or tenants' rights group prevails, that party may recover reasonable attorney's fees and costs in that action. And again, incredibly, if the landlord prevails in the lawsuit against the city or the tenants' rights group, you are not entitled to your attorney's fees and costs. And the last point I want to make is that there's a 4-year statute of limitations on this statute. So you got to bring a claim within 4 years. The tenant or the city attorney or the tenants' rights group. Now, that concludes the overview. I don't know if we can put together on the slide. Yeah, we can do that. So I'll leave you with this. I've negotiated, a lot of tenant buyout agreements that really can be useful. These new rules are tricky, but we're set up to handle them. My buyout agreement now is all in compliance. You just want to make sure that you give me a call or give another lawyer a call, someone with experience in this area. If you start thinking about doing a buyout, and get advice before you ever even mention the issue to the tenant, because you're going to want to make those pre-negotiation disclosures to the tenant, and also do the rent board filing before you even get going. And then you can negotiate the material terms of the tenant. If you came to me or another lawyer who does this and has experience in this area, you'll make sure that the agreement you end up with has all the required disclosures in 14-point type, and the one that has to be near the signature in bold, and all those certain things. So I carefully went through mine and modified it just about on March 6th, actually, to make sure that my buyout agreement conforms to the new law. Any questions?
Yeah. So, the bottom line, what is it going to cost you to clear out a 4-unit building where there's one owner's unit and 3 tenants that actually have to be bought out? How much you going to realistically?
Well, here's the answer to that. The answer to that is that there's no set statutory amount that has to be paid.
Mm-hmm.
What this new law is going to do is going to allow the tenants to have access to what other people in the city are getting.
Mm-hmm.
Okay, so where we might have been able to do, let's say there's 3 units in your building, you didn't have to disclose to the other tenants would have no idea how much. Let's say A, B, and C all live in the same building in 3 separate units.
Mm-hmm.
You were wanting to buy all 3 of them out. B and C wouldn't know what A was getting. Now they will. Now they'll have access to that because it has to be
I
filed.
know that, but realistically, what's it going to cost before we ever get into it? What's it going to be?
You mean as far as like attorney's fees? Or just how much you're going to end up having to pay the
Yeah,
tenant?
attorney's fees, and what are you going to the tenant?
What's the going rate?
Yeah, I think it's going to be tens of thousands of dollars. I don't have a figure for you. There's no set statutory amount. There's no statutory amount.
Can't buy.
They vary.
Mhm.
They vary. I've done them for under $10,000,
Yeah.
and I've done them for several tens of thousands of dollars. It depends on what the tenant wants. What incentive will get the tenant to actually agree to the move out.
So we're easily talking $100,000 here.
You could be. I'm not saying that they're all going to be $100,000, but one way to look at it is that, and one way certainly the tenants' lawyers and tenants look at it is that if you want to buy them out, they take a look at what they're entitled to under the relocation statute if you were to do a no-fault eviction, an LS or a owner move-in, and that becomes the floor for them. I mean, that's the minimum they'll accept.
Yeah.
And then they know that, if you actually had to go through that process, it'd be attorney's fees and time and costs and things like that. And they raise the amount that they demand on that basis.
What do we owe you?
For me, I will say this, for me in doing the buyout agreement, I have a standard form. So once you come back to me, with the material terms, it doesn't take me that much time. I can do a buyout agreement usually in about an hour.
Okay, what are you gonna charge me?
Yeah, it's about $500, $600 to do a buyout agreement.
Okay.
Yeah.
Now, if we have to go to court and negotiate and all that, so I'm owing you by the hour now, or what?
Yeah, it's by the hour, and, but we don't have to go to court to do a buyout agreement. You know, a buyout agreement is actually to use so that we can avoid, you know, going to court, doing an unlawful detainer, serving a notice, and all that kind of stuff. That's why people use them.
What if you went the Ellis Act route? How's that working out?
Well, the Ellis Act is, you have to give the notice. If they're, you know, elderly or disabled or catastrophically ill, they have a year to move out. Then there's the move out, you know, there's the relocation expenses, okay, which are about $15,000, $16,000 up to for a unit. Okay, let's say there's 3 or 4 people in the unit.
Okay.
I don't have the amount memorized right now, but if let's say there's 1 person in that unit,
Yeah.
then you have to pay them, I think the rate is like $5,700, but it just changed, so we'd have to actually look at the number online and get that number. Now, remember, in Ellis, you have to like empty the whole building out, so if you have a whole building full of tenants, you're just gonna have to do the math and figure out how many tenants are in this unit, are they senior or disabled, and then you go on like that, and you figure out, you know, what the math comes out to.
Okay.
Yeah.
And then you can't rent the building, right?
Right, yeah. And then you're
So, you got a marijuana grow room, I guess, and you pay all that off, and it's all okay. Okay. Okay, now, one more question. Suppose you say, I want to rehab all these 4 units here. So, get you guys out, because we're going to have circular saws and blah, blah, blah. Now what do we do?
What are you wanting to buy? You want to buy them out so that you can just
Well,
rehab the
what I want to
building?
know is, what's the cheapest way to go? Should I buy them out? Is there another way to negotiate this thing, or we do that?
Oh, a lot of times a buyout agreement is the way to go. Now, in the past, I certainly would have said that. You know, under the new regime, you know, I mean, part of what makes this new law onerous for landlords is the fact that you have to file that buyout agreement with the rent board so that the tenants are now going to see,
Yeah.
you know, what everybody else got, right?
Yeah.
So as soon as somebody settles for $60,000 down the street, that's going to be the floor for the neighborhood or whatever. I mean, you know exactly how that's going to work. In the past, there was no public disclosure. These were private contracts. And so you could actually, you know, I would enter into, you know, I'd have one tenant in a unit who was motivated and could easily move, and so the amount that we ended up having to spend to buy that tenant out, substantially less than somebody who's, you know, gonna dig in and know they don't have to move and really hold out. So there could be wild disparities. I think what's gonna happen here with the public disclosure is that you'll see the amount of, they'll all rise to a certain minimum.
That's true.
It's only, I mean, the new statute and rules have been in effect only for a couple of weeks,
Yeah.
so I haven't seen that yet. I actually haven't seen that in my own practice where, you know, the tenant comes back and says, well, you know, John Doe down the street got 60 grand, I'm not moving out for 12.
Yeah, they'll think they're stuck or it hasn't now, yeah.
Right. So, I mean, that's really what the effect of the disclosure of the rent board is gonna be.
Yeah.
So do it now before there's any agreements on file.
Yeah, but before, if you're gonna rehab, you thought cashing them out and getting them out of there was the best way to do it.
Yeah, I mean,
Now, do you still think so?
it would totally depend on what the tenant would accept to move out.
Honest?
Yeah. If you could get them out, if you could get a tenant out for less than what you'd have to pay and all that stuff, then it might be. But you know, honestly, it's a case by case basis. There's no blanket answer here. I can't say that to you that going that route is always better than going the buyout route. It's just going to depend.
Right.
It'll depend. But I will say this: it's a lot trickier environment now with the new rules because it's going to be tougher because the price pressure is going to be,
Oh, sure.
yeah, for sure.
Oh, yeah.
I mean, that the amount that you're going to end up having to pay under a buyout agreement is going to be, you know, these guys are now going to know what the prevailing rate is. In the past, I didn't have any idea. The lawyer down the street who's negotiating tenant buyouts and all, I have no idea what his averages. Yeah.
So when you have the two buyouts within a certain period, and you were thinking about condo conversion, does that create a cloud on the title?
It's not a cloud on title. A cloud on title is a very specific thing, but it's not a cloud on the title, but it actually is a restriction on the use of the property, right? You can't.
For the owner right now, but what if you sell the building?
It goes with
Does it
the,
go
it goes
yeah,
with
sold?
the, it goes with the premises. You can't, if you did the buyout, then that premises is no longer eligible to be condo converted.
So that's not a cloud on the title?
A cloud on title is, there's a dispute over who has title. This is just a restriction on how you can use it.
So the restriction
Yeah, I mean,
carries to the
A cloud on title is actually a legal term of art,
So what I'm trying to get at is,
I understand what you're
Carries
saying.
with-
It carries with the unit. Yes, as I understand you're using the term cloud on title. Yes,
I'm
that,
sorry, I guess I.
That's
worded
okay.
it incorrectly, but.
no, I understand what you're
If
talking
that
about.
carries to the next owner.
It does, it's a restriction on the premises,
That's
right?
huge.
Yeah.
So
It
if
is.
you're a
So
real
it-
estate agent, you're gonna need to know, you're gonna need to find
You
out
have to
whether or
know.
not there would be
Right.
these two plus so that you can disclose whether or not it's condo converted.
Right.
So that time window passes,
What's that?
that 10-year time window passes, and you get the first buyout that exits the 10-year period. So,
Right, exactly. Tough new rules.
Yeah, the city didn't
What-
make it
what-
easy on me.
What's in?
Does anybody,
The city didn't make it easy on us.
is anybody trying to protest these rules? And-
Yeah, there is a legal challenge, but it's just getting started. Just getting started. No status update on that.
What if you're a landlord?
The SFAA is challenging.
And how does that look? You really don't know.
It's way too early. I think the lawsuit was only filed within the last month.
Well, I have one other question, it's a little off the subject, but I have a tenant that's trying to, who's been there for more than 20 years and all that, and is a senior. And a few years back, I tried to do a buyout, so she's suddenly running around with a cane, and she's running to catch the bus, and everything else doesn't need a cane, but won't provide me with any documentation as to what her ailments or whatever
Yeah.
Yeah,
Yeah, right.
so,
You have to be very careful. You should call me and be very careful about inquiring into it, because there are restrictions about whether you can ask what the disability is and so forth. You gotta be very, very careful in that area. Yeah, you may have the instinct in your heart of hearts that there isn't a legitimate claim there, but if she makes the claim, you gotta be very, very careful about how you inquire into that and whether you can at all. So,
okay, so then that's
yeah.
going against
But-
your rights, huh?
Yeah, but again, and Colin, could you move the slide back? Oh, one of them.
60 plus 10 years.
Yeah, so in your case, the issue in here in the tenant buyout legislation, for the condo conversion restriction, it wouldn't really matter, the disability would kind of be irrelevant, because if they're over 60 and they've been there for more than 10 years, bang, they're already in there. It doesn't matter whether they're disabled or not.
What if you're a landlord that has already been in discussion? Because it's only March 25th, right? This law didn't take effect till March 7th. So let's just say this in February, we were talking to a tenant about a buyout. Do you now have to start over again on March 8th, 7th?
No, because there's no way that you can comply with the new rules, which were not in effect. You couldn't have given the you weren't required to give the pre-negotiation requirements.
So it's steady as she goes.
Right.
Start over.
Right. Anything else?
So buyout agreements are just another way to avoid the else eviction impacts.
Right. It's like if you go if you go to the rent ordinance online, you can go to the rent ordinance online, and you can read the first. I think it's 37.9E now is the section. Just read it. I mean, the Board of Supervisors spent a long time just laying out what they were really getting at. It's really obvious what was driving them, because they have a long statement of what motivated them. You know, other parts of the rent ordinance don't provide that background, but this new ordinance does. It's a whole page of what the incentives were and what they were getting at, what they were concerned about.
This is kind of off point, Michael, but as long as we're here, suppose you want to peel off the stucco job on Victoria and restore, that's rehab, right? And we can get the tenants out in the case of a rehab.
Right.
Or is there any other problems with that extensive of rehab?
Problems in what way? What do you mean?
Oh, wait a minute, that stucco's got asbestos in it. Ooh, oh dear, you know.
The landlord always has an obligation to do construction, to manage the property, to respond in the manner that a reasonably careful landlord would under the circumstances. Your standard of conduct, I tell people, is always going to be measured against what would the hypothetically reasonable landlord do under the circumstances, okay? And so if you imagine what a hypothetically reasonable landlord would do under the circumstances, that's the legal standard that you're going to be adhered to. That's the legal standard that your behavior is going to be set up against. So for example, if you were going to take the stucco off the side of the building, would the reasonably careful and prudent landlord hire a professional company to take care of that and, you know, take steps to keep the dust to a minimum and so forth? If the reasonably careful landlord would do that, you should too. That's really the standard to always keep in mind in these kinds of questions. And it really doesn't matter, quite frankly. You can change the hypothetical on me 100 different ways. And I'm always going to come back to you with what would a reasonably careful and prudent landlord do under the circumstances? And that's the standard the law is going to hold you to. That's the standard that the judge is going to hold you to. If the reasonably careful and prudent landlord would just go ahead and start ripping it off without taking any precautionary measures to, for example, protect the sidewalk and pedestrians, if the reasonably careful and prudent landlord would not, you know, set up warning signs on the sidewalk to advise people that construction work going overhead, then you're safe to do that. But if you think that the reasonably prudent landlord would take steps to warn people of the risks, to seal the building, to hire a professionally licensed contractor, and on and on and on, then that's what you should do. Yeah.
How much time and trouble does it take to get people out when you're doing rehab?
Well, I mean, it's like anything in the rent ordinance. You can do it, and it's always a matter of, is the tenant going to fight you? You know, it just depends. I mean, some tenants move out and they're happy that you're rehabbing the building. They want to come back in when it's done, but, you know, they'll be cooperative. And others are just, you know, they're the sand in the oyster. They're just irritating and they want to fight you. And so it really depends on the kind of tenant and quality of tenant you have.
What if you never let them back in? I'll just live there, get out of here.
You got it. Whatever you do in that situation, if you're going to rehab a building, you got to follow the ordinance. If after you're done and you have the obligation to offer them the chance to come back in, you have to do that. Yeah. If you don't, you open yourself up to a big claim. Yeah.
You have to offer it to them.
Right. After you do a rehab.
Can't clear the building that way.
Yeah. I mean,
that's what he's trying to do. He wants to do a rehab and clear.
Yeah. I mean, you can't. Yeah. I mean, you can't. You got to offer it back to them. Yeah.
Well, if you never rent it to anyone.
You know, this is a big issue in Oakland. The statute in Oakland is actually kind of ambiguous. It doesn't matter if you're in San Francisco, but Oakland has a weird situation where if you never re-rented it to anyone. But what your point is really prudent. You can't use
rehab
use rehab as a way to clear them out and then just never offer it back. I mean, you gotta follow the statute. You gotta if there's a right to it, you gotta offer it back when the rehab is done. Yeah.
It's actually the old rate too, right?
Correct.
Minus CapEx.
Yeah, right, yeah, minus the recovery stuff, right? Anything else?
I'm probably a unique one here. I'm not even a landlord, but I'm primary. So, good location, should get great rent. Restrictions, you know, the renter has a lot of rights. Should I be fearful about that, or given that rents are pretty high?
You know, I think fearful is the wrong word. I think you just need to be prudent and you need to be educated. Because you can, you know, there are some people that I know, and some landlords that I know that have great tenants. And they, you know, they're able to, it's an income producing property, they have great tenants, but they tend to be the landlords who are, you know, they are the model landlords. They're the ones that are following them, they're informed, they have legal counsel when they need it, they know the rules and regulations, they follow the rules, they do proper screenings, you know, they get the right people in there. They treat it as a landlord-tenant relationship. A lot of the problems I see in my practice are landlord rents to tenant. The relationship is very, very casual for the first couple of years. It's almost like they're friends, right? And they're not. They're landlord and tenant. And then they want to change that relationship because something begins to change between the two of them. They become some acronym comes up. And then you want to start pulling back nice guy and replace him with, you know, law-abiding landlord. Well, that's where you run into friction and problems. So if you enter into a landlord-tenant relationship, particularly in the city with the statute, you just want to be fully informed. So I wouldn't say that you have to be afraid or scared or anything like that. You just have to know that there's a very complex system of rules in San Francisco. And when you're thinking about going into landlording, the more educated you are and the more you follow the rules and treat the relationship as the relationship actually is between landlord and tenant, not between friends, then the better off you're going to be, the less problems you'll have.
That's why a lot of landlords use property management companies, because it takes that element away from it.
Yep.
Especially if you live in the same building, because then the property manager is a third party that is looking out, you know, legally, and it makes things a little bit easier.
Yeah, it really is. That's if I had to give you any advice just in the things that I've learned over the years of working with landlords, that's it. Be smart, you know, be informed, be educated, and treat the relationship as a professional one between landlord and tenant. It's the landlords that, you know, that are just, you know, they want to be the nice guy, and so, you know, they let things slide under the lease, right? Well, then you want to enforce that lease provision, it's waived. You know, it's no longer enforceable. You never insisted on, you know, X, Y, and Z in the lease, and now suddenly you want to enforce that provision. And the tenant says, well, I've been living here for 6 or 7 years, and you've never made me do that before, and now all of a sudden you're insisting on it. And you come in and say, well, it's right here in the lease. And the tenant says, well, we never did that. You know, you never enforce that. It's waiver. It can be. So go in, you know, you go in, your eyes wide open, be educated, be smart. My office is right here. You can call me up. You know, I work with people. I answer the phone and talk to landlords all the time. Should I do this? Should I do that? You know, try to help them avoid some of the obvious problems.
Okay, well,
Great.
thank you so
Thank you
much,
all so
Michael.
much.
Appreciate it.
Appreciate it.